Yes, thank you, Co-Chair Tavares and Deaver and the full commission for hearing this. I think it's important, even if this might be the last meeting of the commission, especially for the legislators here that are on the commission. I really want this to be heard because you spent a lot of time on this. I do respect, I've read through the packet that you had over the last few days. I do respect a lot of the things that you've done. I'm commenting on the things that I don't like. My name's Greg Pace. I'm a co-founder of the Columbus Community Bill of Rights, which is a very grassroots group here in Columbus. And I'm also on the board of the Ohio Community Rights Network. And due to machinations by the Office of the Secretary of State of Ohio over the past 2 years that have curtailed Ohio residents' rights to put initiatives on their respective ballots for county charters, it's been painfully obvious to groups such as the Columbus Community Bill of Rights and the Ohio Community Rights Network that when citizen initiatives push back against corporate interests, their lobbyists have influence from the Board of Elections through the executive offices and the courts as well. Secretary of State John Husted stifled 3 county charter initiatives in 2015 by instructing their respective boards of elections to refuse them access to the ballots. He made claims of being empowered with an unfettered authority when it comes to his review of initiatives by the people. He went on to say that there is nothing to materially limit his scope of legal review of the petitions, including the language and substantive content of the county charters. Fortunately, the Supreme Court did not agree with Mr. Husted on these points and saw the danger of giving one person this authority to keep citizen initiatives off the ballot. These county charter initiatives all had in common Community Bill of Rights provisions that disallow new oil and gas production infrastructure from being installed within their counties because they would violate the rights that people also included in their charters. We all see this eventually when special interests encroach on the interests of the general population to maintain our levels of self-governing democracy in this state. Today, it's the oil and gas industry with their mounds of contributions, not only to the legislative branch, but to the executive and woefully the judicial branch as well. Judges do not recuse themselves anymore from cases when they accepted contributions from the industry they're deciding for or against. Impartiality is eroding on behalf of moneyed interests at the expense of Ohio's residents. In 2016, 4 counties obtained required signatures to place initiatives on ballots for county charters with updated language. Again, Husted kept them off the ballots, and again, the court upheld his decision. His decision for the second year entailed ambiguous rules that he interpreted to decide that county charters did not define an executive authority. The only dissenting opinion on the court was from Justice O'Neill. He said the Secretary of State does not have the power to veto charter petitions on behalf of the oil and gas industry simply because the citizens did not pick exclusively from 2 forms of county government delineated in the RC Code, the Ohio Code. This is a usurpation of power from the people that we should not indulge. Justice O'Neill seems to recognize the importance of the initiative as a necessary check and balance tool of the people in order to alter, reform, and even abolish any form of government that no longer protects safety and happiness. In December 2016, the legislature passed law that now fully shunts the intention of Ohio citizens' constitutional right of initiative. Boards of elections and Secretary of State are now legally authorized to not allow initiatives on ballots when, in their opinion, the language is in conflict with Ohio laws. The importance of citizen initiative is to change bad laws and to propose new laws that they feel protects their safety and happiness, at least according to the Declaration of Independence, which this exactly means that we need to introduce language that could be in conflict with current laws. Please do not give Ohioans the impression that the very commission created to update our Constitution for the betterment of the people is making it even more difficult for the people to exercise our rights of initiative in this state. I applaud the recommendation to take away the supplemental requirement for more signatures after the legislature votes down an initiative amendment, but see no reason to make an adjustment on the voting end to compensate for this. Bringing the requirement for a winning vote from 50.1% to 55% is just plain unjust, and the people see through its intent. No offense. Herbert Bigelow must be rolling over in his grave to see his hard work and sacrifices to obtain the right of initiative for the people as a check on a corrupt legislature and state government being threatened by another corrupt state government 100 years later. I urge you to discard this undemocratic and un-American proposal and take it completely off the corporate table. Thank you.
Thank you, Mr. Pace. Any questions? Mr. Jacobson.
Thank you. No offense taken. To the extent to which you're impugning the legislature, again, we are not the legislature. We are not professionals. We are not corrupt. It would be nice if we earned money here so that we had the potential to be corrupted, no offense. But, it's just not the case. I do wish to note, though, that you began your testimony with some reference to an argument you had with the Secretary of State over the what can and can't be done with regard to county charters. Would you agree that this amendment has no reference to county charters, and in fact county charters are not part of this issue, and initiated statutes and initiated constitutional amendments are not at all the same as what goes on? I mean, meaning it's not in that section or that involvement that what you're referring to is, correct?
Right. Well, I'm using that as a reference to where I come into this room today, to this commission, because for 2 years, we've seen where all of these counties, there's 2 county charters in the state of Ohio out of 88 counties, 2 home rule charters, and now 4 other counties are trying to create home rule charters. When we put language on it that we want in there to get it on the ballot for people to vote for, which is our constitutional right in this state to do, they're not. The Secretary of State disallows it, and the judicial is upholding it. To me, that's unconstitutional. It's absolute unconstitutional machinations by our government on the people of the state of Ohio.
Thank you. I'd just point out that, again, that's working within statutes created by the General Assembly, and the General Assembly did not create, to my knowledge, the ability to write a special provision charter that isn't a charter, that doesn't change the government in any way, but is just a backdoor way to seek a citizen vote on some topic of personal interest. I applaud you for having the passion, but your argument was with the statute and the laws of the state and the way the state governance is set up, and not with the Secretary of State, which is why decision was upheld by the Supreme Court.
Right, and that wasn't really what I'm asking for today. I do not like where you brought the requirement up to 55% from 50.1. To me, there's another way to do this that doesn't, make it hard for grassroots groups like us, to put an initiative on the ballot. There's got to be another way.
Thank you very much, Mr. Pace. We're going to go to the next witness.